Welcome to Germs Justice, a 3-part Facebook Live event presented by Jon Faine, where you get to ask legal and ethics experts your questions about the pandemic and its impacts. Brought to you by the University of Melbourne Law School, Big Ideas on ABCRN and ABC Radio Melbourne.
Hello from Jon Faine. Joining me in the studio, but at an appropriate social distance, are 3 experts from the University of Melbourne Law School, looking today in the first of our 3-part series at privacy aspects, as well as other complications, legal complications that arise from the very quick and deliberate response and concerted response to a public health pandemic. It's taken us decades to develop rules, frameworks and guidelines to deal with such delicate issues as privacy and digital authoritarianism. It's taken us but days to throw those rules, protocols and regulations out the window because of the need to ensure public health. So what happens with the tension that inevitably thus comes? I have 3 University of Melbourne Law School experts with me in the studio. I'll introduce them to you in just a second, but because of the brilliant adaptation of the technologies that we now have access to, you can ask them questions too. You can go straight to the comments section of Facebook Live and pose your question on these issues to my 3 studio guests. Professor Jeannie Paterson is from the Centre for Artificial Intelligence and Digital Ethics and is a professor at the Law School at the University of Melbourne. Jason Bosland is a privacy and media openness expert and is an associate professor there as well. And our 3rd professor is Alison Duxbury. She's a specialist in international law and most of her research is to do with military justice, but today she's having a look at the impact of international human rights protocols on some of the changes that we're experiencing here in Australia at such rapid pace. You get to ask your questions and we'll weave them into the conversation. Jeannie, if we can start by borrowing your expertise, please. We're told that as gradually around Australia, restaurants and cafes, sporting events, gatherings will all be opening up as we come back into a more comfortable milieu. We're told that we'll be required as a trade-off to surrender some of our privacy. For instance, if I want to order a latte and a muffin, I'm going to have to write down my name, my phone number, and assure the cafe or restaurant that I've got the app on my phone. How can that be? And what are the risks inherent in those sorts of processes?
Well, John, it's an interesting new normal that we're moving into, I think. Certainly the Victorian government has suggested that we should be leaving phone numbers, that cafes should be responsible for connecting names and phone numbers, and may ask if we have the app. It's important to note, however, that new legislation passed by the Commonwealth provides that it's actually against the law to require someone to download the app.
So let's put this into a real context. I go in, the cafe says, fine, we'll serve you, have you got the app? And I say, no, I don't like the app. It's an intrusion into my privacy. And they immediately go ding, 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 ding. The next thing they hand me a clipboard and say, well, we have to know your name and phone number for tracing in case there's a problem. What if I say no? Can they refuse me service?
Well, I think the point is that the cafe has been put in an invidious situation. Most cafes are small businesses and they're not subject to the Privacy Act or the protections therein. And all of a sudden they're asked to be the gatekeepers of public health. What are they supposed to do as well? Customers may not like recording that information, but equally the cafe doesn't have mechanisms necessarily in place to keep that information safe and secure.
So I'm not going to put my personal mobile number on a sheet, on a clipboard, which everyone else gets to see. And likewise, I mean, I can sit there and say, oh, who else's name and number is here, and might I just take a note of these? And what happens to the clipboard? What happens to my data? Does it go into someone's collection? Does it go off and get distributed to the world at large?
Well, we just don't know because these questions haven't been answered for us yet. We're all in the same position. We're waiting to see it be worked out. And what I think here is that in the rush to get us back to normal, get us back to work, get the economy working, there's been a series of measures that have been implemented quite quickly without working out the connections between those various measures. On the one hand, we've got legislation that says you can't force someone to download the app. We've got privacy protections that apply to government, large businesses. And on the other hand, we've got individuals and small businesses being asked to comply with a series of measures that they have no experience with and which may have quite profound circumstances for them. And I think it's really interesting because we're seeing shifting dimensions of power and responsibility in society as a result of this pandemic that we haven't started to unpack or understand.
And I love bringing in the Constitution to these discussions because no one's read it, no one knows what's in it, people don't understand it. But how can a state government impose conditions on the delivery of a simple service like a latte and a muffin when privacy is a Commonwealth responsibility anyway?
Because they're not technically in conflict. Because technically the Privacy Act only applies to certain businesses with only a threshold income, and in most cases the requirements that are being introduced now are applying to a totally different type of cohort.
So if a state government, Queensland's doing similar things, if Western Australia, whichever state government it is that wants to create these conditions, technically they're not in breach of any of the current constitutional or other provisions, but they're pushing the boundary a bit, aren't they? They're starting to intrude. And if I can reduce a 5-year law degree to one sentence, by what power? By what power can they make these conditions?
Well, the states have emergency powers which they've been exercising happily, and we've already seen that the states have been able to restrict movement between states and territories in pursuit of protecting us against the pandemic. So these conversations are still being worked out. Now, I'm not a constitutional law expert, so I'm going to pull myself back from the constitutional questions and actually just return us to the Privacy Act and civil liberties. What we're seeing is that because we're delighted to be coming out of lockdown into a new normal, there is a real risk, I think, that we forget to scrutinise, to be vigilant against what you might call creeping government surveillance on us as we move into areas which in the past have been private and personal relationship based and are now becoming the subject of scrutiny from the government.
I'll come back to you shortly. And if your questions relating to any of these issues inspire you to hit the keyboard, just go to the comments section on Facebook Live and send them in, and we'll deal with them all the way through this conversation. And if you want to keep up to date with our live streams, there's 3 in this series of Germs Justice. Make sure you like the ABC Melbourne Facebook page, which is hosting, very generously I should say, hosting this 3-part series. Today we're talking about privacy and the COVIDSafe app. Next week, we'll be talking about workplace and industrial relations changes, which are undoubtedly coming soon. And then the third one, we'll be looking at how borders have been reintroduced between states. It should be absolutely fascinating. You can access all of these on the ABC Melbourne Facebook page. But today, your comments and questions, like the ones that Julia and Joan and Phil have sent in, which we'll work in just a moment, come straight to us from the comments section of Facebook Live. Jason Bosland, if we can turn to you, you're a privacy and media law specialist.
Yes.
These are issues that we've never grappled with, and suddenly they're right there in sharp focus. So how do we deal with this creeping digital authoritarianism?
Well, John, I would, I suppose, challenge the fundamental premise, I think, of that question in the sense that I think we have faced these challenges before. The issue is that the general public hasn't necessarily been aware of it. And what I'm referring to here is really the fact that there is currently a program of mass surveillance of citizens embodied in the metadata retention regime. So we do have a history in this country, and a quite recent history, of governments adopting measures which perhaps don't sit particularly well with civil liberties.
So we've got laws,
Mm-hmm.
we've got rules,
Mm-hmm.
we've got processes and procedures and safeguards, and they're suddenly in sharp focus, if not, in some instances it looks to me, and you're the experts, which is why we've called on you to explain this, but it looks like everyone's just gone, none of that matters anymore.
Well, it's that classic situation where you're required to balance security interests against liberties, and in instances of emergency, I think citizens probably are willing to let go of and accept some forms of surveillance on them, whether it be just not just surveillance, it's also freedom of movement, freedom of expression, those types of things can be curtailed in times of emergency. And I think this is an example of that. I'm not particularly concerned, actually, about something like the COVIDSafe app in its current form. I think it probably balances those interests quite nicely. I have concerns that it might lead to, as Jeannie mentioned, mission creep. But I'm also concerned that we're already there. It's just that people don't know about it. And I think this is probably a really great opportunity, actually, to educate the public about what measures are actually in place to put them under surveillance that they don't know about. Maybe it's an ideal time to reflect upon those measures in light of what's going on.
It's almost as if the pandemic is designed by the people who have always wanted to go down this path and have been looking for the perfect opportunity to say, there you are, look, technology is going to solve this. I mean, whether it's the Mark Zuckerbergs of this world or whether it's the spooks in the back offices that we never get to meet or see in Canberra, in our instance here in Australia, they would have, they think technology is the answer to everything. And suddenly that argument becomes even harder to counter.
Yeah, I think that's right. I think governments are seeing technology as being sort of the solution to everything. You just get an app for whatever you want to try and deal with. The issue, I suppose, is that technology is both the problem and the solution in a lot of cases, in the sense that the technology is there to allow wide surveillance and these interferences in terms of civil liberties, and then what the government wants to do is harness those technologies, whether that be for things like national emergencies or whether it be for things like surveilling citizens in the ordinary course of policing. And so I think that tension between national security and civil liberties plays out in a host of different ways when it comes to technologies.
Are you prepared to put down your name and personal mobile number and download the app in order to get a latte and a muffin?
Yeah, I'll do that. Sure.
No concerns whatsoever?
Not for me personally. I'm probably more concerned about the fact that every time I walk into a place, a ping from my mobile phone is going to the tower, and that's being recorded by telecommunications companies that the government can access without a warrant. That's probably where my concerns lie. I'm not too concerned about putting my name and number down to get a muffin, but I can see how some people would be.
It's Big Brother.
Yeah, sure, it is. But I think that having to put your name and number down to get a muffin is really, I don't think it's a particularly severe intrusion upon civil liberties. I think what is more of an intrusion is what we don't know about, which is this program of mass surveillance, which is currently being undertaken.
Jason, I'll come back to you. My third guest is Professor of International Law, Alison Duxbury. She's from the Asia Pacific Centre for Military Law, but has very generously agreed to extend her embrace of international law for the purposes of our discussion today. The first of Germs Justice is looking at, in particular, the app and the intrusion of some of what I'm calling digital authoritarianism in the middle of a pandemic. And Alison, other countries are grappling with exactly the same issues as we are. We're hardly alone, but it seems that the dictatorships in particular are the ones who are taking full advantage here. Give us some examples of what else is happening around the world.
So thanks very much, John. So as is the case in Australia, many states in the world have imposed border restrictions, quarantine, social distancing, and have also put in place apps in order to trace those the contacts of those who have had COVID-19. Now, in Australia's case, in relation to the app, it is a voluntary app, as Jeannie has already pointed out. In other countries, it's becoming more of a compulsion because it is a requirement, for example, for employees in the public service, or it could be a requirement for using public transport. So there are countries in the world who are taking a different approach. Nevertheless, all countries who are parties to the relevant human rights treaties are bound by the applicable standards, and they include things such as freedom of movement, freedom of assembly, freedom of association, and also, crucially in this respect, the right to privacy.
And they're all being compromised. One by one and with barely a murmur.
Yeah, so on one hand, these rights are all implicated in the types of measures that have been taken place, but it is also the case that there is a recognition in human rights law, and in particular in relation to these rights, that they may be subject to limitations in times of emergency. And so, for example, a public health crisis such as this would be a basis for a state to limit its freedom of movement, for example, or other human rights obligations. However, if it does this, it has to do so to a very limited extent. And what I mean by that is the measure has to be necessary, and it also has to be proportional to the objective to be achieved. That is, the objective of ensuring public health. And so, for example, wide-ranging restrictions on something like freedom of expression, for example, to silence dissent or to prevent criticism of a government's actions, may not necessarily fulfil those criteria and so would be outside the boundaries of what human rights law requires.
These are very rubbery concepts. Reasonableness, acceptable, striking balance, that's incredibly subjective. Everyone will see it differently.
No, that is true. But there are, of course, cases that have considered these matters, that have considered, well, what is actually necessary and what is actually a reasonable limit on what a state can do. The other thing to remember about human rights law is it also imposes positive obligations on the state. So, for example, there is a positive obligation in relation to the right to life, and there is also an obligation in relation to the right to the highest attainable standard of health. And so on the one hand, we can think of human rights law as imposing limits on what states do, but on the other hand, we can also think of human rights law as in actually enabling or having positive obligations on the state in order to take appropriate action. And of course, we all benefit from the types of actions that promote our health and also promote the right to life.
Okay, to questions in just a moment, but just finally, Alison, with you, is it a bit of a luxury when we've got the death toll around the world mounting and, thankfully, Australia not experiencing what's been so incredibly prevalent in many other comparable societies and economies? Is it a luxury to start even talking about rights and privacy when people are dying?
No, I don't think it's a luxury at all. In fact, I think it's incredibly important, not least because, as you've pointed out, that people are dying across the world and that there is an obligation on states in relation to the right to life, particularly those who find themselves in state facilities. So rather than being a luxury, I think that it is in fact an essential part of the conversation, also recognising something that Jason pointed out, and that is that there is a balancing act involved. And so human rights law itself recognises that.
So if you think privacy is an indulgence at this time, well, you can pose your question on the comments section. And if you want to keep up to date with our live streams for Germs Justice, make sure you like the ABC Melbourne Facebook page. Very generously, they have provided us with the facilities. Big Ideas on Radio National will broadcast the audio, and the University of Melbourne Law School has provided us with the experts for Germs Justice. Let's get back to your questions in a moment, but just quickly whipping through between Jeannie, Jason and Alison. Jeannie, is it an indulgence or a luxury to talk about rights and privacy at a time of a national pandemic?
It's not an indulgence and it's not a luxury. It's part of the discussion that we ought to be having to maintain not just our civil liberties, but our identity of what it is to be people, I think. I think we seem to think sometimes privacy is just the right to be in your own home, but privacy is fundamental to a whole load of understandings about ourselves, our right to engage in political speech, our right to live free and autonomous lives. And so, yes, we need to consider the public health outcomes, but we also need to recognise that discussions about privacy are not just discussions about an add-on, they're discussions about what it is to be people and what it is to have meaningful interactions with other people. And the conversation about surveillance is not just about some sort of paranoid view about Big Brother. Again, it's about the role of government and the role of technology in our lives and what we want to be and how we want to live as humans, how we want to relate to each other, how we want to relate to our workplaces, how we want to relate to civic engagement.
Where's the expiry date on the COVIDSafe app? Where's the sunset clause? I haven't heard anyone say we only need this for 2 months, 3 months, 4 months, 6 months, and then everything will be wiped.
Well, if you go to the legislation, that actually information that you collect on your app is wiped every 21 days, and the information that's collected is locked down. Essentially, it can only be used for specified purposes of contact tracing. Now, of course, I've mentioned the possibility of surveillance creep, but there are legislative requirements in place there. But I just want to draw attention to the fact that in some ways we may want that information to be shared more widely. The question's not about whether it's shared, but who it's shared to. Most of us actually want scientists and epidemiologists to be able to understand more about this particular crisis so that we can deal with any crises that come up in the future. So I think the question is not do we get rid of it, but who gets control of it? And is that handed over to private companies, or is it kept within the hands of government? And if it's kept within the hands of government, who within government has access to it?
And this is the same government where individual people in the Prime Minister's office at the very highest level thought it was a lark to distribute a copy of Malcolm Turnbull's book that had been electronically hacked and giving it to all their friends from the internal office of the Prime Minister. And yet they're the people on the other hand telling us we can absolutely trust the protocols that they themselves are putting in place to protect our privacy. I can't resist making that incredibly stark distinction.
I think that's absolutely right, John, and I think that's why we need to have discussions like this so that we all gain a greater understanding of the responsibilities that come with the handling of data. But the tech companies haven't been much better.
They're remarkably reluctant to limit their own reach, and it's hardly surprising they've built unimaginable fortunes off the back of it. Jason, why not let's just go the whole hog? We'll have the surveillance state, we'll have all the cameras turned on, let the spooks and everybody else access our data, and the promise, the trade-off is, but in so doing, we'll keep you safe.
Well, I think that's obviously problematic in the sense that, you're putting trust in a government that has at times proven that it can't be trusted. And I think you touch on a theme, in Australian governance where the public is asked to trust quite a lot. I do a lot of work in the open court space, and there are suppression orders made all the time where the courts are asking the public to trust them. What we're doing either, in the courts that's not being reported in the media or behind closed doors is perfectly fine. Don't worry about it. Trust us. You see that again. I keep going back to the data retention regime. You see that with the data retention regime where there's no real oversight of that regime. But I think in terms of the privacy aspects of the current situation, my view is, and this is my view of the COVIDSafe app, as long as any measure is proportionate and it's effective, I think it's acceptable. And of course, there has to be time limits and there have to be safeguards, and those things are part of what would make the particular measure, in this case the COVIDSafe app, proportionate. I suppose the one reservation I would have about the COVIDSafe app is that its effectiveness hasn't been proven. So if we are to challenge it on any basis, I think in the current climate, I think it has to be whether or not it's effective.
Well, it's been used so far to identify one person in one case.
Exactly. And
something like 5 million or 6 million Australians have downloaded it, although if they've got an Apple product phone, it doesn't work unless you've got it active on your screen all the time.
Exactly right.
And
yes.
It's been used once and identified one contact. Now, for all the money and all the hype and all the energy invested in it, surely that would have been better directed at something more effective.
I think that's probably right. And the figures that I've seen is that, it's 1 in 20 contacts could be picked up by the COVIDSafe app. Now, we're investing a lot of money. We're investing a lot of trust in government in relation to the dealing with the information. Is it proportionate on that front? And that would be the only basis really at the moment that I would raise concerns about the COVID app.
All right, I'll come back to each of you. The questions are coming in thick and fast. Some are comments, and you're welcome to make a comment, but if you've got a specific question, even better. Professors Jeannie Paterson, Alison Duxbury and Associate Professor Jason Bosland, all from the University of Melbourne Law School, are with you now on Germs Justice, the first of a 3-part series looking at the illegal implications of the extraordinary times in which we live. I'm Jon Faine, and your comments coming through quick and fast. Anne says, you give a phone number when you book at a restaurant. First reports suggest they might want an address too in some parts of Australia. Anne says, not happening. I'm not comfortable giving out the details at my local cafe at all. And several people simply say, like Julia, I don't trust the government. When are they going to release the source code? What makes it work? When's it going to be looked at by an independent body? Apparently, they said it would happen in May. Privacy protections were to be formulated. It hasn't happened. Thanks for discussing the issue, and I will not be downloading the app. Alison, we've seen levels of trust vary all around the world on not just this but other issues as well. Trust is a very malleable concept and commodity. Do you think this increases or decreases people's trust in government?
So I think that it has a dual effect, John. That is, on the one hand, when people see that measures are working, when they see, for example, that restrictions on freedom of movement mean that there is a limit in the spread of the virus, then clearly they are trusting government in taking up those measures. On the other hand, the types of comments that you've just read out also suggest that there are limits to the extent to which citizens, including in Australia, are going to trust government in order, and particularly with with their data. Also, as Jeannie's pointed out, in private companies having their data as well. So I think trust is obviously essential, and it's essential for the effectiveness of these measures as well.
Jeannie, you understand this stuff far better than the rest of us. How realistically can government say, don't worry, we will make sure there's no leakage and no hacking of any of the information that's compiled?
Well, they can't. And information that's collected electronically is always at greater or less risk of external attack. But moreover, even anonymised data can often be re-identified. So yeah, there is a risk there. There's a real risk there. And as Jason has pointed out, what we're asking is that risk is balanced by a public health the benefit to public health outcomes. And I think the fact that people are willing to share data in order to have good outcomes is to be commended. But to reiterate Jason's point, we then need to go back and evaluate how useful this app is in promoting public health outcomes. I take the point that we need a lot of people to download it for it to be useful. But even if we get that, if we get lots of people downloading it and the contact tracing's working, we still need to go back and evaluate and say, what is the gain that we're getting here? What do epidemiologists think about the information that's collected from the app? We don't just introduce it and then forget about it. And I think that's a very important point that both Alison and Jason are making, that we want to utilise technology to make our lives better, to promote public health outcomes, but we can't just introduce them and then let them go. We have to introduce them, we have to put governance mechanisms around them, and then we have to go back regularly and evaluate.
We'll be one of the last countries in the world that doesn't go down this path. You have a look, the dictators and despots around the world are not missing this opportunity to tighten their grip through technology on their own population. You look, in Hungary, Viktor Orban has virtually turned himself into a dictator. Needless to say, all around the world. In fact, it's the countries that have the most repressive regimes that are having the worst experience of pandemics. It's really interesting. The most free countries, like Australia and New Zealand, we're very high on the Freedom Index. We've got very low incidence of COVID-19. If you have a look at countries that have removed democratic checks and balances, they've got the worst experience.
I think there's a really important piece of information there. The more you force people to adopt technologies, the harder they may work to evade those technologies or protective measures. But Australia also has, to be fair, a geographical advantage in combating the virus. If you talk to epidemiologists, we just don't have a very big population.
And we don't live as densely.
And we don't live densely. And some of those countries, those very undemocratic countries, also have other factors that contribute to the spread of the disease. But
don't undo my theory, please.
Well, certainly forcing people, the more you force people to use technology, the more we'll attempt to evade it.
And Diana asks exactly that question as I go through the three of you. Diana says, do you see this app being mandatory at any time? If we have a second wave or a third, or as some of the scientists are saying, it might be that we're going to have this forever, might the technology be said to be, along with the remote chance of a vaccine and the prospect of other methods scientifically of dealing with it, might technology be added to the basket?
Oh, I think that's entirely possible. And one of the reasons, as I keep saying, we need to have these conversations. And I know Jason's point that he made earlier about, this sort of creeping surveillance is a real risk here. I guess what I'd also like to say, though, that it's not just the push of government to make us use this technology. It's also the fact that the role of technology in our life is being increasingly normalised. It shouldn't escape our attention that while the app in China is mandatory and you need to use it to get access to public places, in the US, who's developing the Contact app? It's Google and Apple together. Now, that's portrayed as Google and Apple acting for the good of the society, but there must be a trade-off there. I mean, for those companies and being seen to be promoting public health. What else is coming out of that?
Well, they see an opportunity here, which is to make this, as you say, the new normal.
And governance by technology, not by dictator.
Yep.
I'm not sure one is better than the other, that's all.
Which one's more accountable? Neither of them.
Correct.
So we need to get this back. Jason, let's turn to your expertise. If it is mandatory, at some point, Manolo asks, well, who is liable if something goes wrong? What if, for instance, there's a data leak and people then have lost their privacy? Who's responsible for it? Who's held accountable and how?
Well, I'm not sure by making it mandatory the liability for any sort of leaking of data would necessarily change, to be honest.
But it becomes a much more attractive target for hackers, and we've seen how successful they are in getting into every imaginable database, including the security services, the banks, NASA, you name it, they've got into it.
That is true. So if you do make it mandatory or compulsory, then of course the amount of data that's being collected is much greater, and as you say, it may make it more attractive for hackers and to try and take advantage of. But in terms of the leaking of the data and liability for that, I don't think that changes. I suppose the concern is that whether if you do have an app which is made mandatory but its effectiveness hasn't been proven, I don't see how you can say that that's a proportionate interference in the privacy rights of citizens. I would say that would have to be problematic from a privacy perspective. Now, we don't have a right to privacy in our constitution, so that would be very difficult to mount any sort of constitutional challenge based on privacy grounds to this type of measure. But certainly from a civil liberties perspective and from a human rights norms perspective, actually, it would be very problematic.
In fact, Alison, we don't have rights to almost anything by law other than the things that Parliament give us. We don't have a Bill of Rights in this country, one of the very few democracies not to have one.
Yes, that's certainly true, John, that we don't have a charter or a Bill of Rights in Australia. This issue has been debated on a number of different occasions, but we have come to the conclusion, some people have come to the conclusion, I should say, that we do not need a charter or a Bill of Rights. We do have a charter, for example, in Victoria that is similar but not the same as a Bill of Rights.
And it's been considered in several other states who are looking at adopting similar measures.
No, certainly. And so there is now one in Queensland, and of course there is also one in the ACT as well. At the Commonwealth level, what we do have is a parliamentary committee on human rights, which has the ability to scrutinise legislation, including these pieces of legislation that we're talking about now, and to determine whether or not they do impinge on rights, and if so, how. So although we don't have a Charter of Rights, there is a process in relation to the implementation of Australia's human rights obligations at the international level in Australia, but it is not the same as having enforceable rights, including, as Jason's pointed out, the right to privacy. So I should just say that Australia does have international obligations. We have obligations under the International Covenant on Civil and Political Rights, which includes many of the rights that we're talking about now, and that Australia has not derogated from those obligations. And what I mean by that is that Australia has not opted out of its international human rights commitments in relation to the COVIDSafe app or any of the other measures that have been taken. And that is the case with other Western democracies as well. So whereas some states have said, actually, we don't think we can comply with various human rights, we're going to opt out for a limited period of time in relation to these emergency measures. That is not the case with Australia, because we obviously have taken the view, or the government has taken the view, that the types of rights that have been interfered with, for example, freedom of movement, in relation to, for example, quarantine measures, for example, the right to privacy, that what we've done is actually within the terms of the international treaties, because it is for the reason of public health and it is a proportionate and a necessary response. But obviously, just to pick up on something else you've said, if this is to go on for a very long period of time, for example, that these surveillance measures continue, even though, and everyone is very hopeful that the pandemic will ease at some point, obviously, and that these measures won't be necessary. But if these measures were to continue, even if they were not necessary, then I would come back to Jason's point that a question would be raised as to whether or not we then have gone too far and have breached our human rights obligations.
This is Germs Justice, a three-part series borrowing experts from the University of Melbourne Law School to look at some of the legal complications arising from the COVID-19 pandemic. I'm Jon Faine, and if you want to keep up to date with our live streams, it's a three-part series. Make sure you like the ABC Melbourne Facebook page, because they've generously given us the studio facilities. So it's the ABC Melbourne Facebook page you go to. My three professors in the studio, socially distanced, are Professor Jeannie Paterson, Professor Alison Duxbury and Associate Professor Jason Bosland. So many questions coming through. Jennifer writes, this is about values and priorities. Governments have to choose if liberty is more important than public safety. That's a moral judgment. You can't get a perfect balance in regulations. Her concern, writes Jennifer, is that we're not going to know whether it works. What are the impacts on the states of their new laws on public health? How do we measure that? And is it a good measure? And Jennifer, I think we've pretty much covered our panel's views on that, but I'm looking forward to more of your comments as well. Mark is deeply suspicious and says the Privacy Amendment, Public Health Contact Information Act of 2020, which creates the legal framework for COVIDSafe, appears to have no exemption for any of the infrastructure or framework being utilised by, for instance, the intelligence community. So under the Telecommunications and Other Legislation Amendment in 2018, warrants and the like can be issued willy-nilly, and there seems to be, according to Mark, no clear delineation between the two pieces of legislation. So might this area be a fertile ground for the mission creep, Jeannie, that you were talking about before? Let me pose you a situation. We have last time experienced some extreme anxiety in the community about terrorism, all replaced now by the pandemic. Put the two together. If there's an act or a threat of an act of terrorism during the pandemic, it would be irresistible for the security services to borrow and access, surely, the information from COVIDSafe if they think it helps them keep the community safe or track down a perpetrator after an event.
Certainly there's a risk of the government repurposing the data that's collected from COVIDSafe. But I will make the comment that the COVIDSafe data is who people have been in contact with, not where they've been. So you'd need other information actually to geographically
Which
locate.
they have information to. They have access to that already, and they can marry and knit this all together.
Yeah.
We've seen it on Spooks and TV shows like that where they can bring up a screen. I don't know how realistic any of that is. And now we know where everybody is.
Yeah, certainly. It's really hard to anonymise data. All you need is a little bit of extra information, and we can pinpoint what a data point, what a piece of data, who it relates to. We can re-identify it. That's certainly the case, and it just reaffirms Jason's point about the need to keep an eye on this type of legislation that's gradually being rolled out in response to particular threats. I am going to make the point, though, that this is not the last pandemic we're going to have. We do want to learn as much as we can about this pandemic so that we can do it better next time. And I think one of the discussions that we need to keep having is how we gather information that's useful to epidemiologists and scientists and doctors so that they can figure out ways to respond better while also keeping us relatively safe from encroaching state and private sector surveillance. Now, that's a really, really difficult conversation to have, but it's an important one that we have in public with the full light of sunlight upon it, as opposed to brushed aside. Or I think what was happening at the moment is we're just being distracted, in fact. We're being distracted from these big conversations by, little conversations about, well, we can get you back to work, we can get you back to school and the like.
Jason, are you sharing the concerns of our questioner about the temptation for the security services to just, stretch their ambit, stretch their influence and say, well, this is an irresistible piece of information that we'll grab?
Look, going back to your example, I think I have no doubt that if we faced a terrorism threat and that data that's been collected by the COVID app would provide sort of information about who a particular person has been in contact with, I have no doubt that the government would attempt to access that information. I'm not quite sure on the interaction between the COVIDSafe legislation itself and the legislation that the question refers to, which is the Assistance and Access Act. What I would say, though, is that I do have a concern about the latter act that I just referred to, because it really what we've seen over the past 5 or 6 years is really a series of pieces of legislation that have come through which have sought to harness technology for law enforcement purposes. The very first one was the metadata regime. The second one, which the question refers to, was the assistance and access regime. Now, under that regime, technology providers can be required to produce decryption technologies to allow access to otherwise encrypted data for law enforcement purposes. And my concern is that those orders that are made to require that are done so without a warrant. So the question said that they were done with a warrant. That's absolutely not the case. They are done without a warrant. And there's currently a bill before...
Sorry, can I clarify this?
Yes.
You can raid the ABC newsroom. You can raid a journalist in Canberra with a warrant signed by a registrar in a remote rural courtroom.
Yes, you can.
But you don't even need a warrant
to
download rooms full of data.
No. So what I'm saying is that the Attorney General can issue a notice requiring technology companies to produce decryption technologies which will allow law enforcement agencies access to, for example, mobile phones that are otherwise protected by encryption. And that order, that notice, can be issued without a warrant. And it's not
by the Attorney General.
By the Attorney General, and it is not subject to judicial review.
And is it done in secret?
The technology company would know about it, obviously, because they have to comply with it. Yeah, no. So
it would undo the benefit and the purpose of it.
So there is no transparency around the number of these notices being, if any, have been granted. We just don't know.
So that could all be happening without us being in
absolutely
any way aware
right.
of it.
Absolutely. And the Parliamentary Joint Committee on Intelligence and Security is currently reviewing this Act along with the metadata regime as well. And both regimes don't require a warrant. So, for example, my mobile phone metadata that's being produced at the moment, my mobile phone's just here, that is being stored by the telecommunications companies, and that information can be accessed by law enforcement agencies in Australia without a warrant, which to me is extraordinary.
This is deeply troubling. You've got someone in prison in Canberra after a secret trial on a crime we're not allowed to know the nature of, and a trial that was conducted without anyone knowing about it.
Exactly
in
right.
a prison where no one knew that they were being detained. I mean, this is not the Australia... I mean,
and that's
how many years ago, 25 years ago, we were out in the streets over the Australia card and we resoundingly said, we don't want to be that sort of a country where you have to carry identification and be stopped on the street to produce it. Effectively, though, through the use of technology, we've ended up with it anyway.
We have, and this is what is remarkable about this point in time right now is that we have this COVIDSafe app, which is receiving extraordinary publicity in privacy terms. Yet we also have a metadata regime and an assistance and access regime, which isn't receiving any public attention and received very minimal public attention at the time that both of those pieces of legislation were passed. And I just find that extraordinary. So when you're looking at the degree of, when you're looking at the privacy concerns of these various things, COVIDSafe app actually, for me, features as a very sort of minor intrusion upon privacy, to be honest. When you know about the extent to which your data can lawfully be accessed, it is quite frightening.
Jeannie, we've ended up then with a digital Australia card. Whether we wanted it or not, effectively, it seems to be where we're inevitably heading.
I'm not sure about that.
Oh, you can actually say you think I'm wrong. That's all right.
Okay, I think you're wrong. I don't think we're ending up with the digital Australia card. I actually attended the Australia card protests when I was at university, so I remember those well. I don't think we're ending up with a digital Australia card just yet, but I think
slippery slope.
I'm actually worried about something I think is actually more profound. I think we're at risk of ending up in a world where every interaction is mediated by technology. And that doesn't provide us...
We're doing it now. The great irony of this conversation taking place on Facebook Live can't possibly pass without comment.
Actually, well, this is true, but at least you and I are sitting opposite each other and are gaining a whole lot of information from raised eyebrows and drawing of breath as certain questions are asked and comments made. So we're still having a personal interaction. But the thing about the Australian card is we could focus on it. We could focus on it as a site of oppression. But what we're seeing now is diffused, I think, exercises of power, which means that there's lots of different sites where autonomy, control, privacy are being taken out of our hands, and increasingly we're being contained within a world that's constantly mediated by a screen. We've got a screentocracy. And to me, there's a real danger there. And the danger is that it's not a purely public sector or private sector divide. We're almost seeing the conjunction of the two.
You can ask your questions. We've got enough time for some more in the comments section on Facebook Live. And if you want to keep up to date with our live streams, make sure you go to the ABC Melbourne Facebook page because they've very generously given us access to the studio facilities. I'm Jon Faine, and with me in the studio, three professors from the University of Melbourne Law School. Jeannie Paterson, who's an expert in consumer rights, privacy and digital technology. Jason Bosland, a media lawyer specialising in privacy. And Alison Duxbury, an international law specialist as well. Joan and Phil write, are mobile phones with the app at risk of being inadvertently scammed via Bluetooth? If you have scammer devices, you can buy them online easily. If it's Bluetooth activated, your mobile becomes visible to other devices. And we've seen that with some people doing, sort of inappropriate things on public transport, for instance, by sending pictures of themselves doing obscene things to everybody in the carriage and the train they're on. I think there was a couple of notorious cases that were prosecuted through the courts. So what precautions, if any, are being built into this? This is not something I turned my mind to before we came into the studio. I don't know, Jason, is this right up your alley as a privacy specialist?
Well, as a technology issue, it's probably not. But what I will say is that just reading sort of media reports last night, the source code has actually been made publicly available for the COVIDSafe app. Unfortunately, the metadata that sits behind it and also the edits that are made to the COVIDSafe app program, those things haven't been made publicly available. And that has annoyed coders who have been looking at it and trying to work out what its vulnerabilities might be.
So just to explain that means that the formula is available, but the assumptions that they're based on are not available.
That's right. So, and also the edits that have been made to potentially fix problems with the code as well, which I think is very important. I mean, I'm not a coder, so I don't technically know why those things are important. My understanding is that it enables, when you're reviewing code, to work out what potential vulnerabilities have been remedied, I suppose. Now, the media reports suggest that the coders who have looked at the source code of the COVIDSafe app, have identified that there are vulnerabilities. Now, whether or not those vulnerabilities are around the use use of Bluetooth technologies and how they interact both with the COVIDSafe app and also with other phone users, or someone who has a scanner, for example, that might want to steal data via that Bluetooth technology. I don't know. What I do know is that there have been some vulnerabilities identified with it. Now, that is, of course, of a concern. And it also goes to the proportionality issue as well that we keep going back to. Any measure that is adopted, particularly if it's mandatory, must be both proportionate and effective. Now, if there are vulnerabilities there that aren't being identified, then that's problematic, I think.
Alison, you mentioned before that several states now have state-based charters or bills of human rights and others are developing them. How does that then work when you have an overwhelming Commonwealth decision that's been taken? Can the states derogate or opt out? Can they say, well, hang on, that might be the Commonwealth's wish, but that clashes with our state charter and we don't want to go that way? Or is it the other way around, like we saw with the Commonwealth overriding state laws, for instance, with the Northern Territory voluntary assisted dying laws years ago? Does the Commonwealth overwhelm the state charters when there's a clash?
It's not necessarily a case of overwhelming. It's the case that they work in different spheres of operation. So I can take the Victorian Charter of Human Rights and Responsibilities as an example here. So that charter applies to actions of state public authorities. And so that would include, for example, government departments and statutory authorities in Victoria and covers their actions. So it doesn't cover necessarily Commonwealth government actions. So I wouldn't see it necessarily as an example of overwhelming, but rather an example of them working in different spheres of operation. Now, having said that, of course, just giving another example, and you mentioned that it's been used, we know the COVIDSafe app has been used at least once in Victoria in relation to downloading data in order to find the contacts of someone who had COVID-19, and that would be done by a Victorian authority, and so they are subject to the Privacy Amendment Act that one of your questioners asked about or mentioned, but they could also equally fall within the ambit of the Victorian Charter potentially, because they are a Victorian authority. Now, having said that, many of your listeners might be aware of the fact that a piece of legislation was passed in Victoria quite recently, which dealt with a range of different Victorian actions that have been taken. So, for example, in relation to jury trial, in relation to limiting visits in prisons, etc. And a statement of compatibility was lodged in relation to that, where the minister went through the different actions that were being taken and said whether or not the Victorian Charter's rights, for example, privacy, movement, assembly, etc., have been implicated.
I love that statement of compatibility. I'm
Yes.
not sure whether that or screentocracy is the word of the moment for the conversation on Germs and Justice so far, but I love that idea. And we have seen people saying, well, hang on, my human right, in particular people in prison, and lawyers were going to court in lots of jurisdictions saying it's not safe for my client to stay in custody because that's the ideal place to get sick. And therefore, urgent applications for bail or pre-release or whatever else have been lodged in several instances in jurisdictions. How can you use, Alison, how can you use a state law when it's a Commonwealth framework? They're not supposed to be, well, they're not supposed to clash, but they also haven't been integrated in any way at all.
Yeah, so there is a Commonwealth framework in the sense that the Commonwealth as a whole, through the National Cabinet, has been looking at measures that have been taken across the entire country. But as well as that, there are state laws. So many of the laws that we see in place, for example, the ones relating to prisons, as you've mentioned, are actually state laws. And so in those states where there are charters, or those two states, I should say, and one territory where there are charters of human rights, then the state's authorities must act in accordance with those charters. But perhaps more fundamentally, when the legislation is passed, the ministers in those states that are responsible for the various areas that are being covered have to say in Parliament the way in which the measures that are being passed have actually affected rights. So, for example, freedom of movement, etc. So it is true that there is a Commonwealth-wide response, but there is also, as we've very well seen, individual state responses as well.
Would it be fair to say then, Alison, that we're like the scientists, the epidemiologists, we're just making it up as we go? This is uncharted territory, and inevitably we're not going to get it right the first time.
I think it is true that it is uncharted territory. And I think that, as Jeannie has pointed out, this probably will not be the last pandemic, and we need to be prepared for the next. And so...
Not just scientifically, medically...
But legally, yeah, absolutely. We need to think about this in terms of what are the necessary laws, what human rights laws are relevant. And here I come back to my earlier point that, of course, there are positive obligations on the state that we should all be ensuring that the state actually promotes, and as well as that, there are also obligations on the states not to act in certain ways.
So, Jason, what do you want us to do better next time round if we don't want it? We hope it isn't. But if, as everyone says, it's likely, what do we do better next time round?
Well, it's a difficult question. I think
that's the only type we ask here.
Yeah. Look, I think in Australia we've handled it pretty well, to be honest. I think the combination of measures that have been adopted to flatten the curve, if you like, have been quite extraordinary. In terms of the privacy aspects, I think, as I've said, I worry about the effectiveness of requiring, or not requiring at the moment, but potentially requiring in the future. But at the moment, encouraging members of the public to adopt a technology that may not necessarily be effective. And also the issue of trust, I suppose. And, I'll go back to some of the examples that I've talked about earlier. We already... put a lot of trust in the government. There's legislation that I suppose gives governments enormous powers and the capacity to interfere with our civil liberties. So I would say around the privacy issue, I think it's the trust aspect that I think possibly we could think about, at least for the future.
Jeannie, if we were starting all over again, what would you do differently?
I'd bring to the foreground the equity issues. I think that another thing that the pandemic has exposed is the lack of equity within Australian society in access to technology, in access to health, and indeed in access to safe spaces to exercise the right of privacy in. So I think that the equity issues should be first and foremost as we move forward.
Because there's been an assumption that everyone's got access to all these tricks and all these gadgets. In fact, that's far from the truth.
Absolutely. And there's been an assumption that everybody can work and learn from home, when, again, that's far from the truth. And I think those are really important questions to ask.
How do you overcome that, though? It's not like, you can't issue everyone with a smartphone and the latest model and teach them how to use it.
Well, you actually can. You can make a decision that access to technology is just as much a right as access to water and power, because we need these technologies to be able to function in society. And this pandemic has really made it obvious how connected we are to technologies in order to engage in society. And some people don't have that technology. Digital poverty is still a real issue.
But some people are very old, or they're impaired or disabled, or just not prepared to learn new things. A lot of people don't want to learn new things. They're very content with their
That's
life.
right.
And they let all of this stuff wash over them.
Yeah, but people should have a choice about the degree to which they want to engage. There's some people who choose not to engage, and I note here that many people who run tech companies don't let their children have technology. But some people don't have that choice. And if we're going to roll out technology as the answer to distance learning and pandemic tracing, we need to make sure that everybody has the choice about whether they want to participate in those advantages that are being brought by the technology for contact engagement and education and so on.
Don't hold your breath waiting for that, will you?
Oh, I'll keep on yelling, actually.
Well, you're in a very good position to do so, but that doesn't seem to be high on anybody's list of things to do.
I agree, and it should be.
Thank you very much to each of you. Our three experts for the first of the three-part series, Germs Justice, brought to you by the University of Melbourne Law School, Big Ideas on Radio National, and ABC Melbourne, who have lent us their studio so that we could access the Facebook Live technology. Our three guests have been, you've just heard, Professor Jeannie Paterson. She's from the Centre for Artificial Intelligence and Digital Ethics and a professor at the Law School at the University of Melbourne, as is Alison Duxbury, an international lawyer and specialist in military law at the Asia Pacific Centre for Military Law. And our third guest, Associate Professor Jason Bosland, a specialist in media and privacy law at the university. Our next discussion in Germs Justice will be about industrial relations, workplace laws and the changing landscape there. And our third in the series will look at borders. How is it that the Constitution has been put aside and we've reintroduced individual borders? I'm looking forward to you joining us. I'm Jon Faine. I hope you've enjoyed Germs Justice today.